Hello everyone, welcome to SEO's channel. I'm Gauri Kashyap and today we'll be talking about a landmark Supreme Court judgment that held that viewing, possession and storage of material depicting minors engaged in sexual activity is an offence. The judgment was delivered on 23rd September by a division bench of Chief Justice D.Y. Chandrachud and Justice J.B. Pardiwala in a case titled Just Rights for Children's Alliance vs. S. Harish. The decision brings closure to a long-standing split among high courts on the question of whether mere storage of child pornography can be considered an offence under Section 15 of the Protection of Children from Sexual Offences Act 2012 and Section 67B of the Information Technology Act 2000. With this decision, India joins an exclusive club of countries which have explicitly criminalised watching child pornographic material. The judgment overturned the Madras High Court's decision in S. Harish vs. Inspector of Police and another, which had quashed criminal proceedings against a POCSO accused Harish after finding that downloading or watching child pornography was not per se penalised under POCSO or IT Act. First, we look at Section 15(1) of the POCSO Act. This says that any person who stores or possesses child pornography and fails to delete or destroy or report can be punished with a fine of up to 5,000 rupees, on second offence up to 10,000 rupees. Section 15 Clause 2 says that if the possession and storage are with the intent of transmitting or propagating or displaying or distributing, then there may be a higher punishment of up to 3 years of imprisonment. Now, many high courts have interpreted this to mean that the intent to distribute or commercially use such content was essential for storage and possession to be considered an offence. Now let's move on to the Information Technology Act. Section 67B of the Act penalizes the publishing and transmitting of child pornography. So how did the Madras High Court interpret these provisions to ultimately quash criminal proceedings against the POCSO accused? On 29th January 2020, a cyber tip-line report of the National Crime Records Bureau informed the Tamil Nadu police that one S. Harish had been an active consumer of child pornography. An FIR was registered under the POCSO Act. When Harish's phone was analysed by the Forensic Science Lab, 2 child pornographic videos were discovered. These videos had been recorded locally in Tamil Nadu, and investigations revealed that these were children who had been missing for some time. In September 2023, a charge sheet was filed against Harish under Section 15(1) of the POCSO Act and Section 67B of the IT Act. When Harish approached the Madras High Court to quash the criminal proceedings in January 2024, the High Court held that mere possession or storage was not an offence. It ruled that Harish was not guilty under Section 67B of the IT Act as well. An NGO called Just Rights for Children's Alliance appealed this decision in February 2024. They argued that as the judgment was widely covered by news outlets, it would create the impression among the general public that downloading and possessing child pornography is not an offence, and that it would increase the demand for child pornography and encourage people to involve innocent children in pornography. On 11th March, while hearing the appeal, the Chief Justice remarked that the High Court's judgment was atrocious. Justice Pardiwala, who authored the judgment, clearly outlined the scope of Section 15 of POCSO Act, stating that Section 15 provides for 3 distinct offences that penalise either storage or possession of child pornographic material when done in 3 separate intentions. Each intention, as he explained, was considered in each subsection of Section 15. Section 15 Clause 1 penalises the failure to delete, destroy or report child pornography that is in the possession of an accused person. Clause 2 penalizes the actual transmission, propagation, display or distribution of such material. Clause 3 penalizes the storage or possession of child pornographic material when done with a commercial intent. Justice Pardiwala explained that under Section 15 Clause 1 particularly, mens rea, that is intent, is to be gathered from actus reus, that is action of possessing the material but not reporting it. For each case, one would have to go into the facts and circumstances of how the possession came about and why disclosure regarding this possession was not made. By this interpretation, mere possession of the material, unless and until deleted or destroyed or reported by the accused, is an offence under the POCSO Act. Justice Pardiwala clarified that each provision of Section 15 were independent of one another. This put an end to the alternative interpretation that high courts had developed, which read the separate instances of possession and distribution as making up of a single offence. Section 30 of the POCSO Act states that for any POCSO offence, the special court shall presume that the accused has a culpable mental state. That is, if foundational facts are established prima facie, the burden is on the accused to show that he is not guilty. For example, in the case at hand, the prosecution has to only show the foundational fact that the accused was in possession of child pornography and did nothing to get rid of it or report it. The burden lies on the accused to establish that they were innocent. The High Court noted that the presumption of culpable mental state is a factor that High Court should have considered while deciding whether cases must be quashed. Justice Pardiwala wrote that high courts must be slow and circumspect and exercise some restraint while deciding whether a POCSO case should be quashed. While interpreting Section 67B under the IT Act, the court clearly clarified the scope of each subsection. In doing so, the court noted that Section 67B does not only penalize electronic dissemination as per the Madras High Court's interpretation, but also criminalizes possession and consumption of child pornography. Justice Pardiwala also suggested a change in the way we speak about child pornography, particularly in the legal sense. The court observed that in a case of child pornography, the victimization of the minor starts with the sexual act, but continues and deepens with the recording of the act, the perpetuation of the photos and videos, and creates a ripple of trauma for the child. He suggested that the term child sexual exploitative and abuse material, abbreviated to CSEAM, was the more appropriate terminology for the heinous act instead of child pornography. He wrote that it undermines the victimization because the term suggests a correlation to pornography, a conduct that may be legal whose subject is voluntarily participating in and capable of consenting to the conduct. The judgment urges Parliament to seriously consider amending the POCSO to substitute child pornography with CSEAM. It also issued notice to all courts to not use the term child pornography in judicial orders and judgments. Noting that social media intermediaries played a significant role in the dissemination of child pornography, the court outlined their obligation to report the publication and circulation of such content under various laws, an obligation that intermediaries have so far ignored. Judgment reiterated Sections 19 and 20 of the POCSO Act, which imposes an obligation on persons and media, hotel staff, hospital staff, clubs and studios to mandatorily report or give information of any child pornographic material. Section 21 states that failing to do so would result in imprisonment of up to 6 months. The court also made a notable observation on Section 79 of the IT Act. Section 79, which is known as the Safe Harbour provision, protects intermediaries from liability for any third-party information, data or communication link available or hosted on the intermediary. In this judgment, they clarified that Safe Harbour protection does not apply to child pornography. This is because the law also states that if an intermediary is informed by the government that any information, data or communication link hosted by them is used to commit an offence, they must expeditiously remove or disable access. Next, the court directed the Ministry of Women and Child Development to implement comprehensive sex education programs to create awareness on legal and ethical ramifications of child pornography. It also directed that victims of child pornography be provided psychological counseling, therapeutic interventions, and educational support. It suggested that public campaigns on sexual exploitative material should be organized and that at-risk young people with problematic sexual behavior be identified and supported by educators, healthcare providers, and law enforcement. The court directed the Union government to constitute an expert committee that would devise a comprehensive program for health, sex education, and POCSO awareness among children. The court has restored the criminal proceedings against Harish, whose trial before the fast-track court in Tiruvallur, Tamil Nadu will now continue. Thank you for watching SEO's Video Explainer. Like, share and comment and let us know what you think about these latest developments. Don't forget to follow us on all major social media platforms and of course, do read our coverage on the Supreme Court on our website scobserver.in. Thank you for watching. I'll see you soon.